Our Justice Thursday conversation today has legs already because we're going to be going in a couple directions. There have been some rulings that have been made, and there's a high possibility that we may not understand what some of these things are. There's some things that are being said, the rulings that have been given. There is conjecture over things that have been passed over the last couple of years as concerns teenagers, as concerns consensual sex, as concerns the age of consent and punishment. All of those things we're going to be discussing on our Justice Thursday conversation this morning. And we're able to do that today because when we call, they come. Wakili is here with us this morning. Wakili Morara Omoke is an advocate and he's here in the hot seat this morning. Wakili, good morning.
Good morning. How are you?
Very well, thank you. How are you doing?
Good.
Welcome to the hot seat of the Situation Room.
Thank you for the invite. I appreciate it. I could have been here earlier on, but I was not able, and I apologize. I wish I had been here a few weeks before today.
Well, we're glad that you could, because on the day that you're here, there are two major headlines that make them their way into the paper concerning this issue that we're going to be talking about. So it's one that has been there, it's latent, it's been bubbling, but then now here we are with rulings. But before we do that, as we normally do, Dennis will welcome you to today's proverb and share that.
The proverb today comes from Gabon, and it says, even a leopard cub has spots. Even a leopard cub has spots. How would you interpret it?
I think it means that basically that even a leopard as a baby is already, it has the inherent capability of becoming, reaching its full potential. Yeah. So I think I would relate that to, in day-to-day living, that we all have the capacity, the inherent ability to reach our potential as humans.
Well said.
No, indeed, well said. Okay, so how we can start this conversation, because there are layers of this, but there are two things that stand out for us right now. And this is on these two. One, a ruling that has come out of the High Court under Justice Bahati Mwamuye, as well as the split that we are seeing amongst judges when they argue on the age of consent and the punishment. Justice Odunga previously made his thoughts very clear when he said, you know what, and I'm just, you'll use the legalese, but it was clear for what he said. He said, you know what, we shouldn't punish these children who have engaged in consensual sex under the age of adulthood, like we would somebody who has defiled another child. Basically, this is what he said, bringing in the Romeo-Juliet clause. And so now we are at a place where everybody's saying, wait a minute, so what does that mean exactly? From a legal point of view, looking at the age of what Kenya constitutionally decides a child will be a child and not an adult, how do these make sense? Let's start with this age of consent thing before we come back to what consent actually means.
So generally, under our legal system, the age of consent is considered to be, you come to majority, the majority age of 18 years. Our constitution defines a child as anyone who is below the age of 18. Adults are above the age of 18. And the same position is stated in the Children's Act. Perhaps, so that is the position in the law. What the judges perhaps are trying to say is that if a child has made a mistake, has engaged in something which they were not considered to have the capacity to engage in, they should not be punished. I feel like that's basically judicial attempts to bring law reform, but it doesn't give the judges a leeway to go beyond or to engage in judicial overreach. And that's what brings me to the decision that we're under discussion today. The decision of Bahati Mwamuye, that it was just passed yesterday.
Yes.
In that particular case, it's good, perhaps, would you like me to give a context, perhaps, to enable us? That
would be great. Give a context, because then we can come back.
It's very important.
Yeah, it's very important to lay the ground for this. This is where this is all coming from.
Yes.
And then we can come back to your proclamation of judicial overreach, because that's already interesting.
So this decision is High Court petition number 400 E490 of 2025. I have the full judgment. I'll be able to share with you at the end of the program. It's good to also have it and go through it. That petition was brought by there were 4 petitioners. So the first three petitioners were minors. The first and second petitioner are they are males or they are male children who were arrested and charged with engaging in sexual acts with fellow minors. So they were also they was at the time they were 17 years old, and the girls were 16 years old. Eventually, so this found its way to the Constitutional Court to determine the constitutionality of the charges, because the argument they were making is that these were consensual relationships. They were supported by there's a not-for-profit organization called NAYA. That's basically that promotes adolescent and youth interests in Kenya. And there were other parties that came in as interested parties. But the case before the court was basically seeking interpretation of Section 8 of the Sexual Offences Act. Section 8 deals with sex with a minor.
Okay.
Then Section 9, there's Section 9, rather Section 10, which would deal with... so there's Section 8 on sex with minors. Section 10, which would deal with what we call indecent acts with a minor. And there was a connection between these sections with Section 43(4)(f), which basically presumes that children do not have the capacity to make decisions touching on these particular issues or making decisions on sexual contact. So the argument was that it was consensual and not coercive. So they were seeking the court to get an interpretation or a declaration that if it is not coercive, it's not exploitative, then they cannot be charged with an offense. In the end, the outcome of the case was the court seemed to agree with them, in the sense that the court made a decision finding those sections to be directing the various agencies, including the Director of Public Prosecutions, the investigative agencies, to align their policies to distinguish between those two sets of offenders. So if an offender is one who is seen as one who was engaged in a non-coercive, non-exploitative relationship, vis-a-vis the ones who were engaged in a coercive conduct. So that's the kind of distinction they were trying to draw.
Okay. Just do English for us.
Yes.
When you say non-coercive, that means I like you, you like me, we move. Right?
Yeah, that's what
coercive is you take it by force, and you may even defile or hurt at the time. Right? That's the two we're talking about.
Yes.
Okay. So determination for a non-coercive relationship, how do you determine that this one is non-coercive, that these two have agreed?
Exactly. So that's why that's the problem exactly that is created by this judgment, because they do not tell us how to determine those kind of situations. That's the danger in the decision. The other danger in this decision is that it just talks of adolescents very generally. Of course, from general grammar, we consider that an adolescent, in some cases, like the World Health Organization defines them as one who is between the age of 10 and 19. But I think in Kenya, we generally take them to be people between the age of 10 and 17. So you can see they are saying that it has to be minors who are close in age in a relationship, a consensual relationship. So there's a danger there, because if I'm 10 and 11, it's okay. If I'm 11 and 12, it's supposed to be okay. It's a very dangerous.
But the only lines we are playing within this, the lines we're playing within here is for the purposes of determination of criminality. We are saying that if you are looking to charge somebody for a particular crime, had they engaged in sexual activity when one was 10, hey, God forbid, when one was 10 and 12 or 12 and 13, if they had agreed that they like each other and everything is okay, then we cannot charge them. But if a 14-year-old had taken it by force from a 12-year-old, then on that we can charge. That's essentially what this judgment is saying.
That's what it's saying. And
how do you determine that a 14-year-old took it from a 12-year-old by force, or that a 12-year-old gave it up to a 15-year-old without any problem? You were not there in the room, and we already know that the law is unable to interpret situations for which it was not present.
Yeah, that's really the danger that this decision has created. That it has left it at large. Who is to determine that? Because if you have a child and they face a situation whereby let's call this other person a friend who is facing a criminal sanction, they might feel the pressure to simply say it was consensual, even if it was not. So that's the difficulty it's creating, and I think it's very dangerous. The court, I think the court, what I think the court should have done, the court should have called for legal reform on this subject. And there's many other subjects in the criminal justice system that require reform, not just the issues touching on children, but even generally, what are the sanctions available for different types of crimes? And the original sin in this case, I can tell you the original sin is what you call the case of Francis Muruatetu case. And that, I'll trace the original sin to the Supreme Court. So the Supreme Court was faced with an opportunity to give an advisory opinion on whether the death sentence, as prescribed in the Penal Code, is unconstitutional. And there were arguments went on and on about this is a violation of the dignity of the accused person, of the person who is facing this mandatory death sentence. And we went on to this discussion and forgot about what was the violation. Because someone is facing this sanction for a violation that they engaged in. And that was the original sin. So what happened thereafter? Once the court made that declaration, then the courts became confused. We have courts claiming that a life sentence, because now they were given the option of a life sentence. Some courts think that a life sentence is 15 years. Others think it's 30 years. And that is not proper. In a criminal justice system, we need certainty. Criminal law has to be certain. You engaged in a certain conduct, this is the punishment. It must not be left to conjecture and manipulation and interpretation and judicial craft. So the original sin is in the Muruatetu case. It is the Supreme Court which caused all these problems, and now it is cascading down the hierarchy, the hierarchy of the court system.
Wakili, you mentioned about the Sexual Offences Act, which is so clear on what needs to be done whenever this happens, right?
Yes.
But here now, with this ruling that has come from the court, we find that the investigative agencies in the criminal justice system, so the ODPP and say the DCI or the police, when they're investigating this, has this just made it more difficult for them to even present a case in court? Because at the end of the day, when you are now investigating, you have to come with a burden of proof. So, because I'm 17, this one is 13, we are still minors, she agreed, he agreed, or he forced. How do you go about it? Is it just now very difficult to prosecute these matters in court?
There is a difficulty, but at least the court asked the different agencies to come up with guidelines. So it asked the Director of Public Prosecutions to come up with guidelines, and the same is expected of the police, the National Police Service. But definitely it leaves them in a difficulty because, for instance, you use the word close in age.
Yes.
So what is close in age? It's not been defined by the court, and this is not the work of the court actually. When it comes to criminal, when it comes to criminal law, it is better left to the Parliament to define for us what is a given offense, what should be the punishment. And I argue that there is need for reform because even within the Sexual Offences Act, the language is it is not very well written. For instance, when they talk about defilement of children, they have classified, and they have one of the third level is where there is an offense for someone who is engaged in who defiles a child between the age of 16 and 18. Now, when you say 18, again, now that goes to the territory of adults. So I felt clearly here the law should have been properly written to mean between 16 and below 18. But when they say between 16 and 18, so in 18 is sort of inclusive. And it leaves, you can see there's an issue there also with the legislation, but the courts have only made it worse.
So if we were to talk about a proper reform that would come to address the issue that you're talking about, what would be the correct procedure that would then guide a proper and clearly spelled out way of dealing with these matters?
What I expect the court to do is, upon finding whatever it found in the judgment, it should have asked Parliament, the Attorney General and Parliament, to take action to basically introduce either amendments to the law or just to rewrite the law, to repeal and replace the existing legislation. But to just give a declaration and leave it at large, it's very dangerous. But as I said, the original sin is I trace it back to the Supreme Court.
Okay. So there's a problem, right? This is what you're calling the original sin.
Yes.
There was a problem that this ruling essentially was trying to cure, or that the interpretation that led to this ruling was trying to cure. And that, unfortunately, we do have cases where the intent was not criminal, or the intent was not to harm.
Yes.
And so with this, we see that those who may have, because there's a famous case, and because it has been adjudicated on, we can speak about it. There was a young woman, a teacher in this country, who was in a relationship with a young man. He was 17. At the time, she said that she did not know that he was below adulthood, because his physical features made him, you would never have imagined that he was underage. And she was then reported, and the case went to trial, went to court, and she was sentenced to 10 years. We have another case where a young man, and it was 17 years old, and the girl that he had sexual relations with was 16. And she got pregnant, and her parents now took this case to court, and he was then sentenced for defilement, statutory rape, all sorts of things were thrown at him. And that was the time that we started to see cases by Justice Odunga, who said, come on, we should be able to deal with this thing better, because the 16 and 17-year-old were clearly in a Romeo-Juliet case, whereby they had a relationship, but the cultural, traditional, outside the box took it to the courts. So we can see what this is trying to cure. Do we see a problem that it obfuscates when you now open the door? Because then what we are saying if we look at this headline, even if it is misleading, what it means now is that your 13-year-old can start to have sex and nobody can ask questions about it. Because how do you then keep it within the lines of criminality?
So let's start with what problem it creates. Actually, there are multiple problems, because as you mentioned, there are teenage pregnancies. And when you think about it from a large economic perspective, it's a big issue, because if you have children who become pregnant, they have a baby, whose responsibility is it to look after this child? So while you say these children can have because in this judgment we're discussing today, the court is saying that perhaps these children, we should not assume that they do not have the capacity to make decisions. It's also talking about what you call evolving change, rather the evolution of the adolescents, that they are undergoing an evolution. But at the same time, they say these people do not have the capacity to access. They don't have the information to have access to reproductive rights. So there's some internal contradiction. If we have to go that way, then we must think about the whole picture. How do we protect these children against getting into pregnancies? If we just say it's an open check, it will become a monster which you cannot control. So as you asked, what should we then do? It's part of this legal reform. We have to, while we are appreciating these so-called Romeo and Juliet situations, we can't just leave it an open door, because it becomes, once you create a loophole in the law, then anybody is allowed to exploit the loophole in the law as long as it's within the law. So it's a problem. We have to just make sure that all these proclamations are taken through the right process. As I said, this is through legislation. It's through policy change. If we talk about policy change, we have to involve all the actors, from, as I said, from the investigatory to the prosecutory agencies. All of them have to be involved to reach a decision that then covers everybody. And then, you remember, Article 10 was mentioned in this judgment. It's one of the values in Article 10 is public participation. We have to involve, it's a national conversation. So part of it, I believe we have started this conversation today, and it should become a national conversation.
I look at it, there is how this will play up in court, legalese, fraternity, and how you understand it. But from a layman point of view, children should not have sex. Children should not have sex. And the law should then be able to come up with a way that controls that from happening, But that we see this play the way it is. Parents need to come in. We have all the children rights activists, people who deal with children, to also be part and parcel of this conversation. Do you reckon then that if this push for the change and the reforms that are needed comes from, say, parents and the society at large, we would see then even Parliament picking it up and ensure that necessary changes are put in place?
Yeah, you see, for Parliament, they should always be aware of all these developments.
Yeah.
They should be the first one, by the way,
Yeah.
to take this. They shouldn't even be coming later
Yes.
on. They should be leading this conversation. They should come up with a legislation to deal with it. Because, as we said, there is a lot of change, as
Yeah.
recognized even by this judgment. But this change has to be managed because we have to protect the children.
Yeah.
At the end of the day, children need our protection, our care, and we can't just say, now, we leave it to them. They are old enough to do whatever they decide to do because we think that the world has changed. I think we can't just leave it open-ended.
Judges are also split on the age of consent and, what kind of punishment should be preferred on that. In 2019, the Court of Appeal sparked debate over whether Kenya was imposing overly harsh punishment on teenagers involved in sexual relationships and whether the age of consent should be lowered from 18 to 16. And there was a whole hullabaloo about whether that should happen or not. The Supreme Court declared mandatory death sentence was then seen to be illegal. The lower courts followed with the declaration that Sexual Offences Act was also unconstitutional for having mandatory sentences, because that's what it was, blanket. So the minute you find out this was happening, death sentence. You didn't even think about it, didn't even look at the details. The judge there, because the law said mandatory death sentence on anyone who is engaging in sex with a minor, you're going to...
Yeah, I think...
So they said, let's start to look at this a little bit more. And then they started to look at that. And they said, let's lower the age of consent. Now... they're still saying we need to lower the age of consent, and it's still a very public conversation. The Court of Appeal proposed as the age of consent down from 18 to 16. Judges ruled the country to consider changing the Sexual Offences Act, citing lengthy jail terms imposed on young men convicted of defilement, and they said it was too long.
I would agree on that. And I think the Court of Appeal had a better approach because they engaged in what I would call judicial restraint.
Yeah.
While they saw the need for these changes, they did not right off the bat make declarations that would cause occasional a chaotic situation like the Supreme Court did or like the High Court has done in this particular decision. What the Court of Appeal said, I think, is that's a good approach. It's a proposal, and I'm saying this is a proposal that should be picked by the appropriate agencies. In this case, the Parliament, working with the Attorney General and other stakeholders, they should now be working on a legislation. Let's have a conversation, as I said. Let's have public participation. Let's discuss and see if indeed in our country we feel comfortable to go with 16, whether it's 15, whether it's 17. But it should be a national conversation. That's one. Number two, on the issue of punishment or criminal sanctions in our country, I would also agree with the Court of Appeal that we need a reform, a criminal law reform, looking at offenses, because I think that in our statute books we have offenses that do not even make sense, because we have offenses like loitering, offenses against vagrants, such kind of language that was from the colonial times. So we need to look into these statutes, clean them up. Because criminal law deals, law is, there's something called behavior of law. The law is trying to regulate our behavior, and it comes with the necessity. So we have to look at the offenses that we consider to be, that ought to be curtailed by the law today. Let's look at a new list. Let's look at the sanctions. What I call the original sin in the Morara case can be resolved very easily through legislation. We need to sit and decide. If someone took the life of another person, will you still argue that this person has a right to human dignity under Article 28? So they have right to dignity, but not the victim. You see, that's a very contradictory. It's a very contradictory decision.
Yeah. And what makes it a little bit more sticky, Wakili, here is that this ruling by Justice Mamuya yesterday talks about the consent between two minors underage. Now, if you can say that a minor can give consent to another minor, but we still uphold that a minor should not be able to give consent to someone who is an adult, right? Because that's still criminal.
Yes.
Even with this ruling,
Yes.
a minor giving consent to an adult is not possible in Kenya because the age of consent is 16. Well, is 18, but it's being debated for 16.
Yes.
So how can a minor give consent to another minor, but not be able to give consent to an adult? Same minor.
Minor, yeah.
How can that be the case?
Yeah, and those are the right questions to ask. And I think what happens sometimes in our court system is some of these litigations happen. We don't really pay attention until the decision comes out. I think that if an argument like that was presented to this court, maybe the court would have come out with a different decision. But when they sat, in this case, everybody's agreeing with everyone, and the court thinks, maybe it's the right time.
Yeah.
We bring in a lot of foreign judicial precedent. Like in this case, they relied heavily on South African decisions. When you look at the Morara case, it was all about foreign decisions from the European Union to countries that are not even, I wouldn't think that they are democratic enough for us to be considering their judicial precedents. And they analyzed the foreign precedents and they decided now that death sentences are unconstitutional, just from the blue like that. Instead of saying, let's have Parliament look at it.
Yeah.
So the Supreme Court decided to become the legislature. They wrote the law. And there's a lot of confusion that has happened between that time and now. Because initially, once that decision was given, they were applying it to all manner of cases, including the sexual offenses, by the way. Before now, they came up with the Morara 2, where they were saying, it's only for this kind of cases involving where there's a death sentence.
But the problem is that once you open the door, how do you say, okay, we're going to allow the fly in, but we're not going to let the mosquito? We'll allow the fly, but the butterfly and the moth, how do you tell them to stay outside the door? Because the thing is that you don't have an intricate enough sieve to then say, we're going to open it up a little bit, but we're only going to keep it within the confines of 2 consenting minors. You can't do that. Reality doesn't give you the leeway to do that. And we would assume that the court would then interpret and adjudicate, knowing full well that when you open the door, all the vermin flies in.
Exactly. Maybe what I could have expected the court to do, they would have said, you can do it as long as the parents have consented. How about that? So how many kids are going to come and face the parents and say, I've made a decision that I'm going to engage in ABCD?
Because I think what even makes it more difficult to do is, leave alone even giving a consent as an... Because there is the age factor that has been mentioned in that you have to be close in age, right? Yeah. But remember, a child or adolescent, we've said, is 13 to 17. So that means someone who's 13, according to the law, if it's someone who's 14 or 15, they're closer to age. But if someone who's 17, they're far ahead in age. So if a 13 goes ahead and gives consent to 17, is that crime? But yet they are within the same bracket. But if the same 13-year-old can give consent to a 14, what stops them from giving consent to a 17? Or if they can already give consent, not give consent to a 21-year-old because they know what sex is. But that notwithstanding as well, there is the aspect of this conversation also including parents in it. Like you've said, parents as well in that conversation, because in other jurisdictions, if children engage in sex, the parents as well are liable to respond to their responsibility in taking care of their children. So it is not a conversation that can just happen in the courts or in Parliament, but parents as well have to be roped in. You reckon?
I agree. And that's what I was saying. What has happened in these cases, we have left these litigations to some institutions whose intention you do not know. For instance, we have the NIA, the Network for Adolescents and the NIA, Adolescents and Youth of Africa. We do not know what is their goal, who funds them, what is their aspiration, what kind of society they want to see in Kenya. Katiba Institute is there. They have been in many litigations, some very good, but I think in this one they got it wrong. But then the question is, who funds these people? What is their intention? What is the goal? Because you might have institutions out there that are not, they do not love children. They want to see children involved in bad things, and they come here and they go through the litigation quietly. You cannot tell the intention, but once a decision is passed like this, it becomes the law. Unless, hopefully, the Court of Appeal can stay this decision and allow us to have some common sense conversation.
When is a child then deemed to be an adult? If your birthday is on the 21st of May and you were born at 8:30 in the morning, you turn 18 at 8:30, right?
Yes.
Yeah.
On that day. At 10 o'clock, are you an adult?
That's before your time, right? Oh, is it? You said
No, I turned 18 on the 21st.
At what time?
At 8:30.
8:30.
At
So you
10
become
at
an
10
adult.
a.m.
You
I'm
become
an adult.
Exactly that minute. Actually,
Okay.
from the minute you turned.
Last night,
Yes.
I, as a child, could have had sexual relations with a 16-year-old.
Yes.
And according to what Justice Mwamwe is saying today, it is consensual.
Yes.
If it was consensual, didn't take it by force, it was fine.
Yes.
But if I did at 10 a.m. on Thursday with a 16-year-old, I could be liable for criminal culpability.
And very serious ones, because there are 3 levels, as I said, for defilement. There is one which gives you a life sentence. There is the other one that gives you 20 and 15. If you're dealing with that, 11 years below life. If it's 12 years and 15, you have 20 years. If it's 16 and 18, like suddenly again, 16 and 18, the language, as I said, the language is a problem, 15 years. So now, as you said, 18. So should I now come and argue that, but it's 16 and 18,
Yeah.
and I'm just 18?
Yeah.
So there is a danger there that even the legislation itself is self-contradictory. And I would have preferred a judicial intervention which identifies these gaps, recommends them for action by Parliament. Yeah.
Do you think, because I keep going back to what Justice Lenaola said to us here once, and he said, you know what, we would assume that when judges are making decisions that they just read the Constitution back to back, or they read the law or what was prescribed by somebody, and they say they're going to make a decision based on the law, but they take into consideration the atmosphere, the climate, what is going on, and let me now see how I can apply the law to a situation. In Africa, it's not as a liberal society. And when we say liberal, it's not curtailing freedoms, but liberal in terms of letting loose. It doesn't happen like it does in other parts of the world, one could argue. So do you think, or how should that liberalism, or like you say, agenda setting, be played out against what is traditional, carried out by the courts of law? Should there be a relation or consideration of the two?
They should actually. When you look at the mandate of the Supreme Court, let me talk about the Supreme Court now that you mentioned Justice Lenaola. The Supreme Court, one of the obligations they have is to interpret and develop the law in line with our customs. They have to consider the customs. So I think that that's one of the things that perhaps that principle should apply actually throughout the entire legal system, throughout the entire hierarchy of the courts. They should really make sure that even as we decide and develop and advance the law, we must always look at our realities, our culture, and where we stand today. Of course, the idea is to not promote culture that is seen as harmful. And we must advance the ones that we consider to be very good for our society.
It's said that somebody does not fully develop mentally until they're 25. So this 18 that we're talking about, I don't even know where we got this magic number 18, but interesting. Psychologists tell us that by the time an adult is 25, that's when now mental cognizance, whereby critical thinking and maturity then have stepped up to a certain level. But here we are, and we are saying that it is possible. This is the same jurisdiction whereby we are saying child marriage is illegal. Child marriage illegal. Remember, a child is a child until they're 18 in Kenya. And we're also saying that children should be in school and should be doing things constitutionally that a child should do. Can we play in the same space when we have already established some of those things? We've said child marriage is illegal because they've not reached the age of maturity. But something as intricate and as serious as sexual consent, we can leave to the whims of an adolescent from 13 until 19. when we are saying that a human is not starting to embrace maturity properly until 25, and we're also in the same jurisdiction refusing things like child marriage for the same reasons that we are saying that you can actually have consensual sex. How do those things play in the same pool?
That debate really needs to be, and it's a very intricate debate, I would say. Because, you talk about what the psychologists have said. There are also others, biologists, saying that you have your metabolical age, and there's your age. So there are issues here. But I would say that if we have to make decisions touching on age and when you're allowed to make a decision, we need to have clarity.
I dare say some 40-year-olds don't even know what they're doing, but okay, conversation for another day.
Yeah, we need to have clarity, and we need to avoid internal contradictions, because you can't, as you said, you asked if this child can consent to another child, why shouldn't they consent to an adult? So those are very serious questions to ask, and they need to be answered. And the way to answer them is, let's have a legal reform, at least on the issue in the area of criminal law. Remember previously, people were allowed. 15-year-olds would get married 15 years plus before these law reforms came in with the Children's Act and the Marriage Act. Before then, people would marry at the age of 15. There was a reason why we moved away from the 15, because there were children who were being married off, and they were basically they were not going through the education system. So education was being put in jeopardy. They were getting into marriage when they cannot even understand what they are doing. They are too young to decide at that time. That's what we were told. Now suddenly we are told, they're allowed. There's been advancement. So that's what I'm saying. There's a lot of contradiction. We need to have clarity in our legal system. If we moved away from from child marriages, now suddenly we are telling them you can engage. Because actually in this case that was before the court, both the first and second petitioner actually got into cohabitation with the girls in question. Yes. They both got into cohabitation. So you see, there were actually bigger issues, which when I read the judgment, the court seems not to have gotten into understanding actually what the full picture. Like, for instance, for the second petitioner, apparently at the time he was arrested, it was as a result of some domestic disagreement with the girl. The girl is a third petitioner. Yeah. But the court, I do not know if it was disclosed to the court, but in this judgment, we are not told what was this domestic disagreement. Was it an aspect of gender violence, which now led this boy being arrested and now being found to have been cohabiting with a child? She is 17 and the girl is 16. Yes. So you can see the court lost sight of the issues. And that's why I think we can all agree here today that we need a national conversation. We need a law reform that goes for the full picture. Yeah.
Because the full picture for me as well is you are 16, promised to marry someone, and this person is just waiting for 8:30 a.m. for you to get married. At that particular point, is this a child? Is this an adult? And if you are turning 18 and still in school and you're removed from school, then what happens to the Constitution in offering you the right to education? I mean, there's a lot of conversation that needs to be held, that we cannot just leave it at the decision that has been made by the court. We can't just leave it for the reforms that need to happen in the legalese space, but everyone has to be included in that, because it touches on education, it touches on human rights as well, and rights of everyone who wants to have sex as well. So my question then is, with a parliament that clearly has not picked this up, perhaps now from your space, how do we move forward with this matter?
So as I said, this issue requires, indeed, I think, I've been thinking about it for a little while. I think this decision must be what it becomes our reawakening, that we're in a legal system, particularly the criminal justice system, which is in a state of pandemonium. Decisions are coming from different courts that do not that lack harmony. So I would say the starting point would be, let's go back to the judicial decisions that have been passed. There is Muratetu case. Okay. There is this one. There are many others that came from Muratetu where courts are saying a life sentence is 15 years. Yep. So then now we're even interpreting life sentence. Because life sentence means life. You're taken in for life.
Yeah.
Now suddenly courts are saying life sentence means 15 years, means 25 years.
Yeah.
And that's someone who killed another person. So this is the time we need to review all these court decisions. And it doesn't have to come from the parliament. It doesn't have to come from the judiciary. It can be me and you and other Kenyans out there who feel angry enough to sit down and get this work started.
Would you reckon we're angry enough?
I think we are very angry as a nation from many things. And maybe that kind of it kind of kills our focus, because you are worried about the economy, the governance. I think Parliament has become very irresponsible. They are not really legislating. The role of Parliament is to legislate, oversight, those kind of things. They are not doing those things. They are cheerleading, as opposed to they are cheerleading for the executive. Because I've looked at Parliament sometimes doing things with some magical efficiency. You remember when we had the impeachment of Rigathi Gachagua?
Yeah.
It was done, the speed, how the new deputy president, who is now being called a deputy in name only, was elected through Parliament within, the magical speeds. We can employ the same level of efficiency to reform this law. I mean, it means that we can do it, just that people are not willing enough. But it can start with you and me.
So, some of the things, just hear from different groups that we operate in, and again, just following some of these sexual cases and looking at Justice Njoki Ndungu, and then championing the Sexual Offences Act, which is now the Act at that time, that a lot of times when minors, and it is usually their parents who would come forth and say something has happened, and taking it to the court whereby it was understood that somebody who had sexual relations with a minor, it was not sexual relations, it was defilement or statutory rape in this case that was taking place. But then in no time, even after it has gone to the court, somehow magically a family member would come forward and say, actually, no, we choose not to pursue this anymore. We have chosen to settle the matter amicably amongst us. Because there was there was not just an understanding, it was the finding that a lot of these things happened within the family setting. There was an auntie or an uncle, or there was somebody who was the perpetrator in this case. How does this ruling then take those things into consideration, whereby there is now the negotiation with many times money or the promise of money in the future, where I can come and say, well, you know what, how about you go say that it was consensual? And then we're not going to have an issue. Say it was consensual between you and my son, so that we don't have an issue. Does that take into consideration that responsibility or that possibility?
Yeah, I think the court obviously maybe did not appreciate that, but that's exactly what's going to happen. All situations will be turned into consensual. And of course, these are things that I worked on over time. A case will come to the courts as it's going through, being mentioned before the court, through the pre-trial process, or even through the actual trial. Then people will somehow, they will engage and agree on something. And as I said, sometimes it could be it could be financial inducements or some whatever they might agree to, but it has opened a door, and that door, as I said, I will not be surprised starting today, starting yesterday, as soon as the decision was delivered. This is going to be used every day to basically defeat the Sexual Offences Act. But as I said, it's time for reform. And I think the Sexual Offences Act is one of the criminal statutes that call for reform. To just really look at which offences should we have, by offences by which individuals, and what should happen. Yeah.
Do you reckon maybe away from the legal reforms that perhaps there's the time where this conversation became household conversations, in the sense that we live in a society where talking about sex is never heard of. It's not a dinner table conversation. This morning there are parents who don't know how to start having this conversation.
Turn off the radio and run away.
with their teenagers, because it's something that they never did. They do not know how to pass this conversation. Would you reckon that maybe if the overall part of reform that you're talking about as well would be perhaps sexual education in schools, so that everybody is in this conversation?
I would agree. and I would say that also we should, perhaps that's an area that calls for a change in our society.
Yes.
We need to be more open about this conversation. We talk about politics all day long.
Yeah.
We talk about soccer. We talk about the joke of the day. Let's make it also the conversation. Let's talk about all these things. The parents will be able to guide the children better, get to know what the children are up to, who are your friends, who do you spend time around, who are you conversing with, those kind of things. If someone has a friend, let them bring forth the friend. Let the parents get to see who are your friends. Let's see if the children are actually going to come and say, oh, we have certain consent being discussed. And no, the more it's open, children will also appreciate, because sometimes I feel that, it is the case that if an issue is treated with a lot of secrecy, if there is a lot of taboo around a subject, then people will hide and do whatever they deem fit, because as long as no one can see them.
What reforms do you think the Sexual Offences Act requires?
There are multiple. I would say, number one, we need, on this issue of the age, the way we've given age and certain offences that go with a certain age. An example I gave is defilement. It's classified, as I said, from 11 years and below. That is a life sentence. I guess this is considered. This is a child who's really tender. One is between 12 years and 15. Then we give them 20 years. One is 16 and 18. We give them 20 and then 15 years. So if I'm 18, why are we still mentioning 18 years if we say it's below 18? So that's an area that needs clarification.
Yeah.
Now that we have come through the Muratetu era, where a death sentence has been considered to be unconstitutional, then what offenses? What are the sanctions? So the criminal sanctions provided in the sexual offenses also need to be looked at alongside the rest of the criminal sanctions in the criminal system. Yeah. So I would say those are some of the areas that need reform. And now this particular subject we are talking about today, about consent, because Section 43(4)(f) of the Sexual Offences Act has generally said that a child has no capacity to appreciate these issues of sex, and therefore they cannot be deemed to have ability to enter into consent. So if that is the law, and we are saying it's unconstitutional, then you see there is need for reform.
So if that's what the law says,
yes,
and there is what the judge has said, and it contradicts the law, what happens there? Because we know anything else that contradicts the law is null and void. So the court, by that, I noticed that the judge was very careful not to declare Section 43(4)(f) as unconstitutional specifically. He restricted himself to Section. I had mentioned these sections earlier on, Section 8, 10, 11. Those ones, he said, he didn't say that they are unconstitutional, by the way. He just said that we should ensure that when we classify the offenders between those who have engaged in consensual acts and those who are coercive, then we are classifying the offenders so that we do not apply the sections generally. So he has come up with a classification of offenders. But in the law, insofar as children are concerned, there is no classification between coercive and non-coercive, between exploitative and non-exploitative, between consent and no consent. There is no such classification. So for us to apply this judgment properly, then we have to amend the law.
Who would champion these reforms?
It should be everybody. It should be you and me. It should be primarily that is the role of Parliament. But as I said,
we have a slight problem.
We know our Parliament. That is not a priority, obviously. But it should be the parents.
Yeah.
Those of us who are concerned. Those of us who are parents who are concerned that we have thrown something out there that is going to be out of control, which no one can predict what will be the outcome. So the parents, perhaps we the parents have the primary.
With this judgment, the way it is, where it opens a Pandora's box in terms of money would be used to just defeat the whole purpose of that judgment, because you'd come and pay and say it was consensual, underwaters, and to just deal with this matter. How does that then defeat the whole purpose of delivering justice?
It defeats because if people are being paid to make a decision, then how is that actually consent? How is that not exploitative? And you can turn the question. So if there are these who claim to have consented, what about the ones? Rather, if the ones who actually coerced can use this to their advantage,
yes.
How about the ones who consented, but an adult comes to the picture and said, "Now, just say it was not consensual," so that first we get into a financial deal. Something is paid, then now we can turn it back to being.
Yeah.
So you can see it's a big problem.
It is.
It is.
So you talked about everybody being involved in the reform process, because there's, unfortunately, whereby this looks like it has be curing a particular problem, it's like curing just the tip of it, and it doesn't sort out many other things, and everybody can be involved. What are we talking about here? Petitioning.
So one of the things we can do, this
yeah.
I think I'm certain that this kind of a case would go on appeal. The Attorney General should be able to appeal, but if the Attorney General doesn't appeal, actually under the law, anyone who is not happy with a certain decision of the High Court can lodge an appeal. So it means that anyone out there who is concerned enough by this, whether it's a parent, whether it's an organization that is truly dedicated to the welfare of the children, they should be able to come before the court and lodge an appeal against this decision. Or if an appeal is lodged by the Attorney General and they wish not to file an appeal, you can come in you can apply to be an interested party. If you have a lot of knowledge about children, you can come in as what you call amicus. You can apply to be admitted as a friend of the court, and you can contribute. Because I feel like this case, actually, unfortunately, that this kind of a case did not attract the input of amicus. As many interested parties as possible. And I said, because our society, we are too busy with too many things. Maybe such things happen and we are not aware of this kind of litigation. So once it comes out like this is when we are shocked. But as I said, there is an entry point at the Court of Appeal, even in the Supreme Court. You can come in as an interested party and participate in these proceedings and give a different perspective to the court. Because I feel like in this case, the court was just concerned about these the first three petitioners, 2 boys and 1 girl who had a story, and that the court was totally forgot about the larger effect, because a decision like this, once passed, will bind the entire legal system.
Indeed. It's a dicey one, but one that should actually grab our attention or everybody. And, it's about time they've started having these open and honest conversations. Even with these ones that we're saying now need to be consensual, they should be part of this conversation. It's in my opinion. Yeah,
because as you said, the Court of Appeal spoke about this quite a while back, but no one has taken it up.
Indeed.
But as you can see, there's all these things are coming together now. There's Morara, there's what the Court of Appeal has said, there's this decision by Mamuye, and this is the time, perhaps, that we should do something.
Morara, Omoke, thank you very much for joining us this morning. Justice Thursday conversation, opening some of these things up for us. A lot of things are hidden sometimes because we don't talk about them, and so that's why it's good that we do. Asante Sana for being here.
Thank you. It was such a short 1 hour.
I know. Time flies when you're having fun.
All right.
For us to talk about these things that matter. But thank you. And
thank you very
much.
much. Thank you for the invite.
Good morning.
This is the Situation Room, the only way to start your day.